My client is a male in his mid-20s working as a business banker with ANZ who has just completed his business degree and planning to start up a business mentoring companies that are looking to expand into international markets. The client's objectives are to be able to put on more staff that are experts in business in other countries to create a business that will be the place people go for any international trade. There are 4 main ways the client could structure this business venture, either as a sole trader, a joint venture, partnership, or as a company. And I would be advising the client of the advantages and disadvantages of each to assist the client to choose the most suitable one, but will be focusing on the partnership and company structure as these are the most relevant to the client. As a sole trader, the client would be conducting their business alone without the benefit of any separate legal structure or entity status. The disadvantages of this structure are that the client would be managing and financing the business all by themselves and would have unlimited personal liability for all debts and obligations of the business. The advantages are that there is no legislation specific to governing sole traders and hence very few regulatory requirements besides the usual rules of contract, tort and consumer protection. As a result, it would be a simple structure and there would be no formalities accompanying the formation, conduct, transfer or termination of the business unless they are required to register an ABN or business name. The client would also own all assets and profits. However, in our interview, the client mentioned that they were wanting to associate with their friend and colleague to run the business, as the client has $200,000 to invest and qualifications to offer, and the friend speaks Mandarin and knows how to do business in China. This gives the client the options of a partnership or joint venture structure, which are more advantageous to the client than a sole trader, as it combines their skills and resources. A joint venture would not be a suitable structure, however, for the client, as this is generally used more for a one-time activity and the client is wishing to pursue an ongoing business. And under the Partnership Act, they will be recognised as a partnership as they will be carrying on a business in common with the view to profit anyway. As per the case of Wiltshire and Kew Ainsley, this will occur regardless of whether or not the client and the friend regard themselves as a partnership or not. As a partnership, the client and their friend will both own and run the business together and share financing, assets and profits of the business. They will owe fiduciary obligations to each other under equitable principles confirmed by the Partnership Act, specifically requiring them to act in the interests of the partnership and not to compete with the partnership business. The advantages of a partnership for the client are similar to that of the sole trader structure, in that it is another simple and informal structure, as they would have very few costs and formalities associated with setting up, conducting or ending the business. There would be no registration or other formality to start the partnership or end the partnership. It can be formed simply by the client and their friend's conduct or them just forming a partnership agreement. It would also be a flexible option for the client, as in the internal structure, rights and obligations of the partners would be governed by their own partnership agreement. Anything not covered by the agreement will be regulated by the Partnership Act, which requires no reporting and ongoing formal requirements and obligations. The lack of reporting or registering also means more privacy for the client. The disadvantages of the client choosing a partnership structure are also similar to that of a sole trader structure, as a partnership is also not recognised as a separate legal entity. As stated in Sadler and Whiteman, they could use a firm name, but only as convenience. It would not make the partnership a separate entity. As a result, both the client and the friend would bear unlimited personal liability for the debts and obligations of the partnership, and personal assets would be at risk. As per the Partnership Act and Cox and Hickman, partnerships carry even greater risk as partners are agents and combine the firm to joint obligations. Under the Act, they would have joint and several liability for the tortious wrongs committed by each other, or joint liability for unauthorised contracts entered into by each other, even without their knowledge or without fault, if these acts are done in the ordinary course of the business. This will be an issue for the client, as they mentioned in our interview, the risks of setting up a business, particularly of being sued, were a great concern of theirs. Another disadvantage of the partnership not having its own legal status is that it may be affected or dissolved by events such as death or bankruptcy of the client or their friend, as per the Partnerships Act. This would also not really suit the client, as during our interview they advised they wanted the business to carry on going in these circumstances, so they would need to put provisions in their partnership agreement in regards to this. The alternative structure to a partnership that may be suitable for the client to choose instead would be that of a company. To form a company instead of a partnership, they would need to incorporate under the Corporations Act and register with the Australian Securities and Investments Commission. As a private company, the client would own the company as member and shareholder of the company, and if they wish, they could also run the company as director. Profits would either be shared out amongst themselves, them and their friend, and any other shareholders in the form of dividends, or reinvested in the company. A company, unlike a partnership, is legally recognised as a separate entity from the client and their partner and any other shareholders as per the Corporations Act and Solomon's case. As an independent entity, this means the company has legal capacity and power the same as a legal person, in the sense that it can enter contracts, sue and be sued, own property, and incur debts all in its own name. In Lee and Lee's Air Farming Limited, the court held that the main shareholder and governing director of the company was a separate person from the company and could negotiate an employment contract between the company and himself. This would have the benefit of permitting both the client and their friend as shareholders to limit personal liability to outsiders for the losses of the business to the extent of the funds that they have invested personally in the business, which in the client's case is $200,000. This allows them to ensure that their personal assets are protected and not at risk if their company is sued or anything goes wrong. As directors, they would only be personally liable if they continued to trade during bankruptcy. This is another aspect of the separate legal entity of a company which makes the structure more advantageous than the partnership. As a separate entity from its members, a company has perpetual succession and on the other hand, and would be unaffected by these events. Having a company limited by shares also has advantages, as in that it would be easier for them to grow their business and increase capital to the extent that they wish to by issuing shares, and easier for them to sell shares of the company as they mentioned they wanted to in the future. The only real disadvantage to the business of the business structure is that of practical implications. In particular, that it is generally a more formal and complex structure than a partnership and less flexible. Under the Corporations Act, they would most likely have more setup requirements, ongoing reporting and disclosure obligations such as the company's financial situation. However, in the client's case, due to their estimated revenue being less than 25 million and size less than 50 employees, it would likely be regarded under the Act as a small private business, and so is likely to be less complex, especially if themselves or the partner are both shareholder and director, and they would have less obligations than a public company, such as not having to go to have the annual general meeting. It is also not much of a disadvantage for the client, as they mention that they are wanting to purchase an office, work cars and things as such, and put in the time and effort to set up the business properly. In conclusion, based on the client's particular situation, there are advantages and disadvantages for them choosing either to adopt a partnership or a company structure, and either would be suitable depending on what the client wishes. However, in weighing up the legal implications and practical aspects of both, I'm going to recommend to the client that they choose to incorporate into a proprietary company, as there are many more advantages for them as a company than a partnership, and from the information they have advised me, I think that would better suit their needs. Incorporating would address their concerns of risk and liability and protect their assets, while the partnership offers great risk and no protection. It would also better help them grow and finance the business and suit their future needs better, as it will enable them easily to keep the business going despite certain events and sell it easier.